These are part heard appeals in the matter of Maynard and others and Thames Water Utilities Holdings and others.
Yes.
Thank you, my Lord. Just 2 points to pick up from yesterday, if I may, before we go back to dealing with valuation. The first is, you may recall yesterday I gave you some figures for the level of participation in the super senior financing, which is 93.29% of the Class A and 74.8% of the Class B. Looking back at the transcript at page 92, page 197, line 2, I think I misspoke and said 24.87%.
You did actually.
Yes,
I did wonder at the time.
Yes,
74%.
it was 74.87%, not 20.
Just fractionally short of 75%.
Exactly. So I was selling myself short on the point. And in fact, I had the right figure written in my notes, so it was my error in just misspeaking. But that obviously needs to be corrected. And we make the obvious point, there is a high level of participation from the Class B creditors in the super senior financing. The second point is, I made some submissions yesterday about, Mr. Phillips' point, based on the fact that the valuation in Bluebrook was carried out on a going concern basis. I made the point that the fact valuation is carried out on a going concern basis doesn't mean that the question of whether a creditor or shareholder is out of the money is not carried out by reference to the relevant alternative. The type of valuation you use depends on what would happen in the relevant alternative. But also there's another point which I should have made, which is the valuations in the present case were both carried out on a going concern basis. So this is a case before your lordships where the judge found that on a going concern basis the Class B were out of the money. So, and both valuers approached it on that basis. We'll then sort of pick up where we were yesterday, if we may, and I made some introductory points about criticisms of the judge's approach to valuation. I'm going to turn to deal with the specific issues, the first of which is Totex. If we could begin by going to the judgment at paragraph 181, which is in the core bundle at page 172.
Yeah.
The way the judge dealt with this was effectively to accept our factual case that the response to the draft determination provided the most reliable figure for Totex. And as he said, the Class B HG did not submit that TWL had any prospect of meeting the final determination Totex figure, nor indeed did they challenge the DDR figure directly. As he notes in the next sentence, there was effectively a hypothesis by Dr. Grunwald that the figures may have been inflated in order, effectively as a negotiating ploy as part of the back and forth that was taking place with Ofwat. But as he says, in the absence of a very detailed breakdown, I accept Mr. Cochrane's evidence and I find that the DDR figure provides the most reliable guide to the group's actual Totex. Now, we put on evidence from the Chief Financial Officer of the group, who is Mr. Cochrane, and he attended and he was cross-examined. If you go to the supplemental bundle, divider 25, page 967, paragraph 4.4, he dealt with this point, and specifically he dealt with it in relation to the position having now received the final determination. So in circumstances where the negotiation process with Ofwat, if I can call it that, had ceased, because actually we've now got Ofwat's final determination. And as he says in the second sentence, at present, the Totex figure included in the DD response represents TWUL's most accurate available assessment of the expected costs in AMP8. And then he effectively says it's not clear to him on what basis Dr. Grunwald had used the Totex figure from an earlier business plan. And my lord, he was cross-examined in front of the judge. The judge concluded he was an honest and straightforward witness. That's the judgment at paragraph 282, subparagraph 3. And the judge was entitled to accept that evidence, having heard him being...
Was it actually specifically put to him that they'd inflated the figures?
No, that was going to be... Your lordship's ahead of me, because that is exactly my next point. It was not put to Mr. Cochrane in cross-examination that the Totex figures in the DDI had been inflated.
I didn't read that bit of the judgment as saying they had been inflated. He's just making the generalised point, the perfectly obvious in one sense, if you're looking at it in a general sense, that might be something that you would do if you were negotiating. That's really all the judge is saying. But he then goes on saying the next sentence, but here, on the specifics, I accept Mr. Cochrane's evidence.
Exactly, exactly. And your lordship's absolutely right. It wasn't put to him that it had been inflated. And obviously, if it had been put, he wouldn't have accepted that. Now, the point about an absence of a breakdown of a Totex is misconceived. I mean, what they've sought to do is sort of latch on to that comment which the judge made in the absence of a very detailed breakdown and say, well, because you didn't put a very detailed breakdown before the judge, you have failed to discharge the burden of proof. We deal with this in paragraph 63, sub 2 of our skeleton argument. It's a bad point because they had available to them a number of breakdowns of the Totex. That there is a breakdown of the Totex in both the final determination and the draft determination response. Those documents, as you might expect, don't simply have a single line that says Totex. They break it down. And as we explained, it was also broken down within what's called the Project Crabtree model, which is essentially the group's internal live model, which it uses to effectively produce projections, and that was provided to Dr. Grunwald. And the other materials we refer to, the business plan, the technical due diligence report, and the business units plan. All of this material was well available. If they'd wanted to put forward a case based on the breakdown, they could have done so. Now, there's also a point made to say, well, the gap between the Totex allowance in the financial determination and the group's figure for Totex in the draft determination response is alarmingly large, if I put it like that. That is not a good point because it's not comparing like with like. The Totex figure in the final determination is an allowance. It's effectively what Ofwat says a notional efficient water company would need to spend in order to hit its objectives. So it's effectively saying this is what will allow you to spend. Now that is different from Thames's assessment of what it will actually need to spend, and it's common ground that at present Thames is not a notional efficient water company. It doesn't hit that Ofwat standard, and if the whole purpose, one of the purposes of the plan is to facilitate a recovery programme, and as experts explain in their reports, by 2030 it will get back to that standard. It's projected, but at the moment it isn't, and it's entirely understandable and indeed logical that there is that gap at present between what Ofwat says it ought to spend and what Thames thinks it will in fact need to spend in order to hit its objectives. Now, my learned friend also made the point that the gap between the draft determination response and the final determination is unprecedentedly large, in the sense that if you look historically at how big those gaps have been, the present gap is larger than it has been in the past. That, in our submission, isn't a good point, or at least there's a very obvious explanation for it, which is that at present the water industry is undergoing a step change in investment requirements. So the amount water companies are required to spend has increased hugely. So given the investment requirements, the expenditure requirements have increased, the gaps it's not necessarily surprising there's an increased gap between what Ofwat says needs to be spent and what the planning company, someone like Thames, says it will actually have to spend. And just on that point, if I can just show you Mr. Wera Singh's first report in the supplemental bundle, divider 6, page 212.
Sorry, which volume is it in?
Sorry, this is supplemental volume 1, divider 6, page 212.
Yeah.
And I don't think we need to get into it, but if you just look at the first paragraph on the left-hand side, it gives you an idea of the change, the step change in investment requirements. So in PR2, PR24, DD, which is the current price review, we're concerned with. Ofwat has proposed an 88 billion spending package for water companies, more than triple the investment for the previous period. So what has basically happened is Ofwat has recognised there needs to be increased investment by water companies generally in infrastructure. The investment, projected investment has increased hugely, and therefore the fact that there's an increased gap is simply a function of the fact we're dealing with much larger figures here. And I put this to, if you go in the transcripts bundle at divider 4, page 260. So transcript bundle 1, page 260. I had a discussion about this with Dr. Grunwald, and if you pick it up at the top of page 183, line 1, the position at the moment is that the water industry sector needs to attract an unprecedentedly large amount of investment, doesn't it? Yes. The figures are enormous, aren't they? But it's a step change, the amount of investment that's gone in previously, hasn't it? Yes. And then she makes a point, and exactly that's why I'm saying Ofwat has to be extra careful, in fact, aim high in its returns to make sure that the investment will be coming in. And then if you go down to page 184, line 18, at this point I'm quoting from a report produced by Oxera Consultant on the water sector, line 90. But if we go to 4398, the point I want to draw to your attention is, can you just see under the heading in green there is a paradigm shift in the financing into the sector. It says this, and then you can see effectively a quote that reflects what Mr. Wera Singh had just said. And then page 185, it's right, isn't it, that the level of investment required into the water sector at present is unprecedentedly high? Yes, I think we've discussed that just now, and that's exactly the reason why Ofwat has to be extra careful in ensuring that the returns are generous and attractive. So that is the answer to that point. Now, on the aggregate sharing mechanism, if we stay in the transcript bundle, this was dealt with by Mr. Wera Singh in his answers in cross-examination. So staying in day 2, if we go to page 178 of the transcript, which is page 170 of the bundle.
That can't be right. Day 2?
Yes, day 2, so it should be, I'm sorry, we're now in divider 3, I do apologise, we've gone back.
Day 3.
So day 2, it is divider 3, page 170 of the bundle to page 178 of the internal transcript.
Right.
This is the point about the second cost-sharing mechanism.
Yes.
That's right, yes. So if you go to line 13, this is Mr. Phillips putting questions to Mr. Wera Singh. So at line 13, And then there is a second, I'm sorry, I called the first part the ASM, it is the second sharing mechanism that is the ASM, so that's the aggregate sharing mechanism. And then Mr. Ware said, correct, once one fuse fails, it's the next fuse. And then Mr. Phillips put to him, the portion above that then is shared between the customers and Thames 50/50. And Mr. Versing says, I cannot definitively say yes or no because we had a discussion with Thames Water on this. The ASM is a new mechanism that was introduced for this AMP period. Thames themselves were unclear as to how Ofwat intended for the triggers to be set off. In the initial business plan, because of that uncertainty, Thames Water didn't actually model that in. We sought to look at it because of the uncertainties we didn't. And then line 7, you did not take this into account. It says, I did not because there's a lot of uncertainties to how it would be applied and I would be guessing at best. And then he says at line 11, however, I did for your lordship's benefit have a sensitivity in my supplementary report based on what we understood it to be as a result of Dr. Grunwald's challenge. And then if you put it, he finishes then at line 20 through to 22. Again, I had the discussion along with my colleagues with Thames, and it's not clear even to Thames how that would be implemented. So this is something he looked at carefully. Ultimately, he didn't consider it was something he could properly rely on as part of his valuation because of the uncertainties which he described. He was prepared to include a sensitivity on it, but not incorporate it into his valuation. And in my submission, that's entirely proper and reasonable approach for him to adopt.
What do you mean by including a sensitivity? Because the valuation wasn't changed in any way, but there was some caveat to it.
Well, the purpose of a sensitivity is illustrative, really. It doesn't form part of his valuation, but it illustrates how that issue might have an impact on the valuation if it was to be incorporated. But the key point...
I think, like my lord, I'm not sure I'm following the point. I mean,
yes.
Either did the amount of the valuation change
No.
as a result of the sensitivity? Or was it just a sort of note saying the following additional sensitivities might change the figures?
It's the latter.
Yeah.
Exactly the latter.
Which gives rise to a slightly different question. If you're talking of trying to identify whether a creditor is out of the money or not, you have to come to a definitive number because you're comparing one number with another. But when you're considering the fairness approach, and of course that's where this comes in on appeal, not before the judge.
Yes.
There's going to be a range of valuation is an art, not a science.
Yes.
And so there'll be a range. So it would be wrong, wouldn't it, to say, because at stage 1, that is whether the creditor's out the money, we came to a valuation of X, we shut the door on considering fairness issues if the creditors were out of the money on that basis, when actually the range of valuations meant they might have been in the money on within that range.
Well, he did, he obviously did have a range of valuations which which essentially reflected different inputs. I mean, what he basically said, his central proposition was his central case valuation, but he had a low and high.
The middle range one.
Yes. So basically how this works is he had a low valuation, a central case valuation, and a high one, and those different valuations reflected various different input changes into the valuation. What he was in fact saying was that, yes, exactly. So what he was in fact saying was, if you take my central case valuation, if you take a sensitivity of 750 million, that still leaves you within the range of my low to high case valuation. That's effectively what he says in his supplemental report. If we go to that.
This isn't so much a point about the experts' valuation, it's about the judge's approach to valuation, though.
Yeah. But ultimately, I mean, the judge made a finding on valuation, and he essentially accepted on valuation Mr. Weresinger's central case. And in my submission, that was right and entirely open to him to do. And what Mr. Weresinger was saying is that he's not prepared to include the ASM within his valuation for the reasons he's described in cross-examination. It's too uncertain. He's discussed it with Thames. Thames don't know how this is going to operate. It's something which he, as a professional valuer, is not prepared to include. And just one other point on this, just to illustrate perhaps the uncertainty about the issue. In her evidence, Dr. Grunwald suggested that the impact of the ASM was £1.8 billion. That was her evidence. Now that's been effectively abandoned, walked away from now, but that's what was being put forward by the other side as to what they say the impact was. And there's no attempt to uphold that at all. So the aggregate sharing mechanism, Mr. Wersinger dealt with it, gave very clear, coherent reasons. The judge was fully aware of that, and he accepted Mr. Wersinger's valuation, which didn't include as part of the valuation a figure for the ASM. In my submission, he was fully entitled to do that. Now, we then come to the question of the WACC, the weighted average cost of capital. Now, as your lordships know, both experts adopted essentially the same methodological approach to valuation. So they applied a DCF, discounted cash flow model, which involved assessing the value of the group's future cash flows and then discounting them to a present value. And in order to discount them to a present value, as part of the model, one has to use this concept of WACC, the weighted average cost of capital. Now, there was some differences between the two experts in the WACCs which they used. The main difference between them related to what is called the risk-free rate. Now, that is a component of the WACC calculation. It reflects the return which an investor could get by investing in the UK on a risk-free basis. So, or to put it another way, it's the risk-free return which an investor is giving up by investing in the asset which is the subject of evaluation. So it's almost like one of the baseline components within your weighted average cost of capital. You have to include the return which an investor could get by investing risk-free within the UK. Now, the normal proxy for that in relation to an investment within the UK is the nominal yield on a 20-year UK gilt. So that is your basic standard risk-free investment. So what these valuers would typically do, and what Mr. Wersinger did, is use the yield on a 20-year UK gilt as being the risk-free rate. And the idea is that by investing in Thames, that is the risk-free return the investor's giving up. Now, and that's exactly how Mr. Wersinger approached it, and I think what might be described as the conventional way. Dr. Grunwald's approach was a little more convoluted, it's fair to say. If you go to her first report at divider 15 of the supplemental volume 2, page 550, so paragraph 3.57, and you'll note she begins by accepting that Mr. Wersinger's approach is standard for a normal business. And that's right. But then she says it's unsuited to a regulated entity such as Thames Water. And this point takes a little bit of unpacking. If you read the next two sentences, what she says is that the difference on the yield between a nominal gilt and an inflation-linked gilt implies a view of current inflation in the UK. So if you take the difference between a yield on a nominal gilt and the yield on an index-linked gilt, you can say that that impliedly reflects a view of current inflation. And she puts that at 3.3%. And what she then says is, well, that implied current view of inflation is different to the inflation assumptions Ofwat have used within the model to inflate both revenues and RCV. And therefore, what she says, if you get to the final sentence of 3.58, she says, essentially she's saying there's an inconsistency. Now, Mr. Weerasinghe didn't accept this because he explained that actually the inflation rates are doing two different things here. Ofwat is using the inflation rate effectively to increase the value of the asset itself over time, whereas the purpose of the nominal rate on the gilt is to reflect the return which an investor is giving up now by deciding to invest in Thames rather than to buy a risk-free investment in the UK. So it's two different things. And the fact that Ofwat, for the purpose of its model, uses a 2% interest rate is not inconsistent with the fact that the decision of the investor now to give up the nominal UK gilt implies a different view of inflation by that investor. They're two different things, and there's no necessary inconsistency between the two. And if you go to his Mr. Weerasinghe's supplemental report in supplemental bundle 3 at divider 23, page 892. He made this point very clearly. In its paragraph 4.2.5.
Yeah.
And you pick it up really in the third sentence. This conflation of regulatory determinations with an investor's opportunity cost obscures a key distinction. Ofwat's real risk-free benchmarks are used in a system designed to protect customers against inflationary risks and to set allowed returns for a notional efficient water company. So that's the point, that Ofwat uses the inflation rate for the purposes of increasing revenues in the RCV. Investors, by contrast, look to current or spot nominal government bond yields as a starting point for evaluating their required return on capital. As an investor's minimum required rate of return is dictated by prevailing market conditions, not by rates employed for regulatory consistency. Consequently, I consider it appropriate to select a nominal gilt yield which corresponds to the real-world opportunity cost for an equity or debt holder seeking to invest in TWUL. I cross-examined Dr. Grunwald on this at some length. I think Mr. Phillips asked Mr. Weerasinghe some questions about it as well, and the judge ultimately preferred the analysis of Mr. Weerasinghe, paragraph 184 of his judgment. And in my submission, he was perfectly entitled to come to that conclusion. In fact, the judge was right. We submit Mr. Weerasinghe is plainly right. But what you can't say is the judge was plainly wrong about this. And in fact, there's also a further point which is perhaps worth making, which I also put to Dr. Grunwald. If you go to Mr. Weerasinghe's supplemental report at page 901 in supplemental bundle 3, and this is paragraph 4.5.4. there's another point which Dr. Grunwald lost sight of. Her gap, her implied inflation rate of 3.3% represents the current inflation rate, because it's looking at the current position between the yield on a nominal gilt currently and an index-linked gilt currently. Ofwat's inflation assumption is in fact stretching forwards to 2040. So you're not actually comparing like with like anyway when she makes the inconsistency argument. And what Mr. Ware-Singh does in 4.5.4 is that if you actually look at the position on a forward-looking basis, there is only a gap of around 10 basis points, because actually on a forward-looking basis, the inflation rates become much closer together, and the market view of inflation is much closer to the assumption of 2%, which has been used by Ofwat. So the 3.3% and the 2% isn't the right comparison anyway. And
So
that,
is that, I understood Mr. Singler's argument not to be challenging the rate per se, but the inconsistency
yes.
in using it for cost of debt.
Yes.
And he said it should have been used the same rate for cash flows.
Well, I think he puts it the other way round. I think, yes, but exactly, it's the inconsistency point, exactly. Yes. But so Mr. Ware-Singh's first point to say is there isn't an inconsistency, because actually they're doing two different things. So the 2% inflation rate is used by Ofwat to inflate revenues and the RCV. The nominal rate on the gilt is used to assess the opportunity cost which the investor gives up by investing now. So they're doing two different elements.
Does that necessarily explain why you use those different rates when you're assessing the cost of the debt and applying it to cash flows?
Yes, because what the choice for an investor is, you're coming along today and you've got a sort of range of investments in the UK. And a possible investment is to invest in the debt or equity of Thames. And you know that part of the benefit of that asset is that it will inflate, the customer revenues will inflate at 2% over time, because that's Ofwat's assumption. But nonetheless, the opportunity cost you're giving up by deciding to invest in the debt and equity of Thames is the nominal rate on a UK gilt, because that is the alternative investment you could make now. And the fact that the value of the asset is inflated by a particular inflation assumption doesn't mean that your opportunity costs, which you're giving up, is any different. So that's why, I mean, it's a little bit of an involved point, which perhaps illustrates my overriding point as to why there isn't a basis for interfering with the judge's conclusion on this. But we don't accept there's a necessary inconsistency. And then the second point, which Mr. Ware-Singh made, is even if that wasn't the case, the 3.3% is just taking a snapshot now of the current market expectation of inflation, whereas the 2% used by Ofwat is looking at the inflation expectation out, I think, to 2040. And he says, well, if you look at the market expectation out to 2040, the gap, in fact, is much closer, and it's not 3.3 versus 2. It's closer to 2.1 versus 2. So that, so ultimately, I mean, it was a point on which the experts had different views, on which they were cross-examined. As I say, the judge preferred the view of Mr. Ware-Singh. In my submission, Mr. Ware-Singh was right, the judge was right, but in any case, the judge wasn't plainly wrong. You heard both of the experts cross-examined on this. Now, there's also then...
Well, that's because there's no reason the judge would have accepted Mr. Ware-Singh's
Yes.
evidence. So the judge has made an evaluation of the evidence.
Exactly. But
It's not for this court to interfere with.
exactly.
Even if we thought that we might as it were, individually or collectively, reached a different conclusion.
Exactly. I mean, that's why, right at the start of my submissions, I, again, risk of teaching my grammar to suck heads, talk you to those paragraphs dealing with the approach on appeal. But this is a paradigm example, something where the judge came to a view.
Yeah.
And I mean, I do make the point as well. I mean, the judge made this point in his judgment, and this is a point which you can't really replicate in this court. Undoubtedly, he thought that Dr. Grunwald's approach overall was a bit academic.
Well, that's the point that's made, isn't it, at the end of 185?
Yes. I mean, he wasn't being sort of hugely critical in making that point, but it's just when you looked at their different approaches, her approach, you could say, was, you know, perhaps a little academic, and you could see that from her background. She's an economist rather than a valuer by profession, and I think he thought Mr. Wera Singh was perhaps the more experienced professional valuer involved in the cut and thrust of doing valuations from an investor's perspective. That was part of his evaluation. He'd heard them both. I put that point to Dr. Grunwald about her being academic. She didn't accept it, but he heard her answer on it. And he came to his conclusion. So there's then a point made. This is the second point in relation to the WACC, which my friend Mr. Singler developed, and this is in relation to the Trua mechanism. So this is separate from the ASM, as we call it. Dr. Grunwald said that because Mr. Wera Singh had increased the cost of the Thames debt in his supplemental report, he also needed to take account of a Trua mechanism. Now, Dr. Grunwald was wrong about that for reasons I'll explain in a moment. This point, it was somewhat unsatisfactory the way it was introduced. It came in Dr. Grunwald's supplemental report, for which she didn't, in fact, for which the Class B AHD didn't, in fact, have permission. So it came in late in a supplemental report after the reports had been exchanged. So it wasn't something Mr. Wera Singh had an opportunity to address in either of his reports. He nonetheless dealt with it in cross-examination. If you go to the transcript bundle, volume 1, at divider 3, page 165, so this is within day 2. And so it really begins at line 12 on page 158, and it's put to him that he hasn't taken account of the Trua mechanism. So if the cost of debt was higher, there would be an adjustment by way of compensation to the company at the end of the regulatory period. Do you follow? And then he says, my understanding of that is that this is an industry-wide increase in the cost of debt, but it wouldn't be company-specific. And then you get the same point, which he comes back on at page 159, line 7, through to lines 15, where he repeatedly makes the point that this Trua mechanism works at an industry level. Now, just to unpack that, what he was saying there is the Trua mechanism is not triggered by an increase in Thames's own debt, so it's not something that's company specific. Rather, it's triggered by an increase in debt at industry level by reference to an index. Mm-hmm. So the short point is that the fact that Thames's own debt has increased in cost doesn't trigger the Trua mechanism. The Trua mechanism is triggered at an industry level by an increase in debt across the industry, which in fact is measured by something called the iBox index, of which Thames in fact doesn't form part. So he rejected the point. It's a little compressed, the cross-examination, I accept that's because he wasn't asked many questions about it. but he rejected the idea that there'd been any error by failing to take this into account, and he explained why. And he, in our submission, he was right about that as well, absolutely right about it. And it's Dr. Grunwald who was wrong. So that's the WACC. We then come to the question of the multiple applied to the terminal value. So again, as your lordships will probably be aware, DCF value, you effectively assess the value of the cash flows out to a particular period of time, which in this present case is 2040. Then you get to 2040, and then you work out what's called a terminal value at that point, which then forms part of your overall valuation. And the question is how was that calculated in the present case? Now, both experts in fact agreed on the methodology, because they agreed that the way you should work out the terminal value is to apply a multiple to TWUL's RCV, its regulatory capital value at that time. But they disagreed as to the multiple that should be applied. So there's quite a large measure of agreement, in fact, on methodology and disagreement as to what multiple should actually be inputted. Mr. Wera-Singh applied a multiple of 1, and Dr. Grunwald applied a multiple of 1.2. That was essentially the disagreement between them. Now, the judge again preferred Mr. Wera-Singh's approach, and you see that in the judgment at 188 to 190. Perhaps if we turn that up, it's in the core bundle at page 174. It's interesting, the judge described this as a shortcut, but in fact, it really, the way he approached it went to the heart of the issue, it seems to us. And what his basic logic is this. Both experts were proceeding on the basis that by 2040, the group would have returned to industry standard performance. In other words, that as at 2040, it would be an average performer. And in fact, what's projected to happen is, at the moment, the group is a poor performer.
Yeah.
It's going to go into a recovery program. By 2030, it should be at the stage of being an average performer, and then it's assessed it's going to stay as an average performer. So by the time you get to 2040, the terminal value, it would be an average performer. And the experts were agreed that as at 2040, Thames would be an average performer. Now, Mr. Wera-Singh's point, our point, and the judge's point, is that if at 2040 Thames is merely an average performer, then there's no reason to think it's going to attract an EV RCV multiple of more than 1. Now, and that's because Ofwat's approach to determining RCV proceeds on the assumption that if you're an average performer, your RCV should equal your enterprise value. Yeah. Now, if you're an outperformer, if you do better than the average, you're likely to have a multiple to your RCV, because investors think, well, actually, you're doing better than Ofwat allows. That leads to a premium being applied to your enterprise value versus your RCV. But that only applies to an outperformer. And the judge's essential point, Mr. Wera-Singh's essential point, is to say, well, if you're saying Thames is only an average performer at 2040, what's the basis for applying a premium to its RCV in order to reach an enterprise value? And that is the essential point. Now, my learned friend, I think, latched on to paragraph, the first sentence of paragraph 190 of the judgment. I mean, for our part, we don't really understand the criticism of 191st sentence, and it seems to us to encapsulate the point entirely, because what he's saying there, quite rightly, is Dr. Grunwald's use of 1.2 implies, perhaps one might say he should have said implies rather than assumes, but implies that TWL will not only have returned to NPV neutrality, but will have significantly performed Ofwat's expectations. And he says, I would not be prepared to accept that submission without clear evidence that TWL's current forecasts and projections are likely to achieve that outcome, and this is the market's perception. And indeed, you might add to that, the experts were both proceeding on the basis it would only be an average performer as at 2040.
Yeah.
Now, the other point he quite rightly made there is he dealt with Dr. Grunwald's reliance on historical transactions. So one of the things Dr. Grunwald tried to say was, well, that logic might make sense, but if you look at historical transactions, there are examples of water companies who are average performers who've attracted a multiple to RCV. So that essentially was her riposte. And we went through that in cross-examination. The basic reason why those historical transactions are unreliable is that in the past, Ofwat had a very different approach to regulation. And what the judge is referring to there specifically is to the degree of leverage allowed by Ofwat. In fact, let's pick it up in the transcript.
Yeah.
So if we go to I put this to Dr. Grunwald. If you go to the transcript, bundle 1, divider 4, page 256.
Yeah.
So you pick it up at line 9.
Which page?
So page 165 of the internal transcript, page 256 of the bundle. So line 9. The other point, I've already made these, but these are historical transactions. At the time these were entered into, the type of financing that was available to water companies, water and sewage companies, through, for example, wholesale business securitisation is not necessarily available now, because Ofwat has tightened up the restrictions on leverage. Do you accept that? I think what you're saying is not the type of financing, but the leverage that the companies were able to execute at that time. I believe that is right. That the level of leverage you can put in today reduced, but nonetheless you can put in leverage higher than the 55% notional level that Ofwat has, and that's what Ofwat uses to work out the return a notional efficient water company is allowed. And then if you go to line 8, you see against line 12, she accepts that the ability to do what's called a wholesale business securitisation has been removed in effect. So as my learned friend Mr. Phillips explained earlier, the financing structure of Thames is a wholesale business securitisation. The ability to do that has in effect gone because Ofwat's changed the rules. And then line 17, yes, but what I was going to suggest to you is at the time a number of these were entered into, the degree of leverage an investor could apply in order to juice up their returns in effect is less than they're able to do now. I'm not saying they're not able to do it at all, but it's less, isn't it? It's less than it used to be. And then I said, that affects, doesn't it, the reliability of these comparable transactions. And then she says, I think you'd need to show how much the multiple is given by financial leverage, how much by generosity of Ofwat, how much by strategic considerations, how much by control premium, how much by other factors. So she doesn't quite accept the point, but she accepts the change in the regulatory environment, and she accepts that the returns which investors can get is less, and she also accepts that in order to look at how useful the historical transactions are, you need to investigate how the premium on those transactions was in fact made up. And that's obviously what the judge had in mind in paragraph.
She wouldn't accept the point.
No, she didn't.
The point you put at
She didn't
Page
concede.
167.
Yeah.
The comparison with United Utilities,
Yeah,
which was a better run company.
that's exactly right.
In other words, what you were putting to her, there isn't really your 1.2 based upon historical performance is an inaccurate way of looking at it.
Yes, exactly.
And you know, whether she accepted that or not, the judge preferred Mr. Weir Singh's
Yes,
which he was entitled to do.
exactly. And he clearly had that in mind, and that formed part of his reasoning in paragraph 190. So, those are the points on the sort of elements of the valuation. And I mean, in our submission, the judge dealt with this. We would submit very well, actually.
Yeah.
He's identified the key issues. He's decided them in a way that's perfectly proper. We submit he's correct, but in any case, he's not plainly wrong. Now, there was then a important point which the judge made at 191 of the judgment about the cross-check in relation to the trading price
Yes.
of the debt. And the point the judge made in the first sentence of 191, we submit is self-evidently a good point. Ultimately, one of the things a valuer should do is take a step back from your DCF model, look at what other evidence there is, and ask yourself, if nothing more than a sense check, is the output of my valuation consistent with the other evidence which I have? And that's not to suggest that the trading prices are themselves correlate directly to the enterprise value, but it is a sense check. It's a piece of available market evidence which allows you to think, well, have I got this broadly right, or have I got it wildly wrong? And that's, in our submission, the function of this. Now, if you go to the supplemental bundle at divider 6, page 261, in Mr. Weir Singh's first report, he included this as a cross-check. And as he says, as a cross-check, page 261 of the divider 6.
Yeah.
So he included this right from the outset in his first report as part of the analysis. As a cross-check to our estimated enterprise value of the current day, we estimated the value of TWU's publicly traded debt. Taking into consideration TWU's current financial difficulties, we believe that the current trading value of the company's outstanding publicly traded debt is an appropriate cross-check to the estimated enterprise value as of the current date. And then if you go down to the penultimate bullet point, on the market data, the Class A bonds were trading at a 20% discount, while the Class A loans trading at a 30% discount, and the Class B debt was trading at an 85% discount. And in the final bullet point, they say, we estimate that the value of the currently publicly traded debt, applying those discounts, is around 14.1 to 14.5 billion. And that was effectively within line with his enterprise value, which was 14.729 billion. So he's done the cross-check and said, well, look, this is what market tells me about the value of the debt, and that is in line with where he's come out on enterprise value. Now, those figures are wildly out with Dr. Grunwald's central case valuation of 21.496 billion, because her valuation implied that the Class A and the Class B debt would all be paid in full, with value in fact breaking in the subordinated debt. So if her value was right, someone holding Class B debt would expect to be paid in full. Now, the obvious point is, well, that doesn't really tally with the market evidence that people are trading the Class A debt at a discount, let alone the very substantial discount on the Class B debt. And one of the things she sought to then say in cross-examination, well, is you must sort of almost ignore these figures because they include the prospective effect of the restructuring. But that wasn't a good point either, because I took her in cross-examination. If you go within supplemental bundle 3 to divide a 43, I took her to this chart which shows the prices of the Class A debt over time, generated by Bloomberg. And you will note that in fact there's two very significant reductions in the price of the Class A debt. The first is in the end of March, beginning of April, and we agreed with Dr. Grunwald that's when the shareholders in effect walked away from the group. Yeah. And then the second is very interesting. Right at the start of July, there's a precipitous fall, and that's when the draft final determination came out. So what investors looked at was, that final determination is very bad for Thames because it's not allowing it sufficient revenue, and therefore sell off in the debt, prices go down. Yeah. Relevance of this, that isn't triggered by the announcement of the restructuring, that's triggered by what the view investors are taking of the prospects of Thames in light of the returns which Ofwat are going to allow it. So in our submission, this was it was pretty good evidence actually as a sense check, a real world sense check. Is Dr. Grunwald right to think the Class B debt's going to be paid in full? Market information would put at lowest a rather large question mark against that. Mr. Worsing also dealt with this in his supplemental report in divider 23 of volume 3 of the supplemental bundle at 902. And you see 4.6.1, he makes the point that the only way Dr. Grunwald responded to this in her first report was essentially to note about the nature of the Class B debt that was being traded. So she says some of the Class B debt is not being publicly traded, and therefore conclusions you can draw from that trading prices are limited. But Mr. Worsing makes the point, well, that doesn't address the discount on the Class A debt.
Yeah.
And then she makes the point, he deals with 4.6.3, the timing point, which I've already dealt with. And then 4.6.5, as discussed in my first report, market participants' willingness to purchase or sell a security at a discount or premium to face value captures both the company-specific underperformance concerns and market interest economics. And then he goes on to explain why it is that he considers in Thames' case it captures the company-specific underperformance concerns. Yeah. And the judge in our submission was entirely right to place weight on this evidence. I mean, he was also right to be critical of Dr. Grunwald. She didn't really have an answer to this in cross-examination, as the judge noted. And it was a piece of evidence he was entitled to rely on. And again, I mean, to say that the judge was plainly wrong for placing the weight which he did on that is, in our submission, fanciful. Now, there's then, I think, just by way of sweep up, there's 2 points I need to deal with. There is a point made about the burden of proof, which essentially, and I think Mr. Singh puts this as his first and primary way of putting the appeal. In fact, as I understood it from what he said in his submissions, he says the judge should have decided this on the burden of proof, and he says the judge should have decided we hadn't discharged the burden of proof and effectively thrown his hands up and said, you're not there, it's all turns on the burden of proof, and I'm not going to sanction the plan. In our submission, that's unsustainable as a submission. The judge had written an oral evidence, expert evidence from both sides on the point, qualified experts. He had submissions, oral and in writing, and he was clearly able to deal with the points in his judgment in a way which is commendably clear and to the point. And indeed, my recollection and understanding is the Class B AHG before the judge weren't making the submission which my learned friend is now making to your lordships. They were saying he should prefer Dr. Grunwald's valuation. Yeah. That was their case. And in any case, there's no basis for saying the judge shouldn't have decided the points. I mean, we've referred your lordships to the Re-A case, which essentially says it's only in an exceptional case the court should decide an issue by reference to the burden of proof. In saying simply, I'm not going to decide the point. I'm just going to leave it to rest on the basis that the party required to prove hasn't discharged the burden of proof.
That ties in with my earlier question, if I may say so, because the ultimate question here is not what's the value of the company. The question here is, as before this court certainly, is it right to ignore any objections or any apparently unfair treatment that someone who is said to be out of the money gets in this plan when it comes to the horizontal fairness test?
Yes.
And the mere fact that you've reached a definitive view, as you have to do if you're trying to value something
yes.
of X, doesn't discount the possibility, leaves open the possibility that X may be wrong. It's an art, not a science, and you're looking into the future as to what this company might do in the future.
Yes.
So you can't, can you, say, well, because I've reached that definitive view, I shut out thereafter entirely any consideration of fairness as regards those who fall on the wrong side of the line? Or do you say it's that stark?
We do, because this point is by reference to the relevant alternative in our submission. So you're not looking at the question of whether they're out of the money in the abstract. It's not an abstract concept. In our submission, I made the submissions yesterday, it is framed by reference to the question of whether the whether the creditor or shareholder would get a return in the relevant alternative, which in many cases, including this case, would be an administration or a liquidation. So it is a concrete concept because you're looking at whether they would get a distribution out of that alternative situation. So I do submit, and that's the way in my submission it's been looked at in all the cases to date.
But that doesn't quite answer the point, because in the relevant alternative you can't say the value is absolutely X. It might be more than X. You're saying that you've got to shut out the possibility of unfairness, considering unfairness to the distribution within the plan, to those who are out of the money having arrived at that figure. Now you may say, well, yes. What else can the court do?
Quite. Yes, I mean, I do say that. I mean, A, it's right, but B, what's the alternative? I mean, it just becomes absolutely unworkable if you take this sort of alternative approach to say, well, I've decided what the value is and they're out of the money, but then, well, I might be wrong about that, and therefore I'm going to allocate some value under the plan. If so, what value? How do you calculate it? Someone's inevitably going to come along and take issue with what you decide. I mean, it becomes so uncertain that it would render the whole process absolutely unworkable. And in my opinion, it's not how the cases have looked at this at all. And just going back to the sub-scheme cases, going back to how we always used to do this, it would be perfectly acceptable in a scheme case to produce a value showing that the alternative to the scheme is a liquidation. In that liquidation, the creditors in question wouldn't get anything, and on that footing, leave them out of the scheme, leave them behind with their claims against Oldco, and transfer the assets and liabilities over to Newco, in which would be owned by the in-the-money creditors. And that whole approach is based on an actual valuation of looking at what their likely actual return would be in the insolvency.
And you say it's the same if the plan is effectively affecting a distribution, as in the case where the plan is merely buying time for a company to recover. It may be another plan later down the line as here, or it may be to recover to profitability.
Yes, and on the out of the money point, I mean, where I do say that, because the alternative to this plan is a SAR now.
Yes, but not a distribution now. It's not a distributing SAR.
The SAR would take its course. I mean, there's a question about how long the SAR would take. I mean, where I do rely on that point, obviously, is for a different reason, which is to say, well, even if you do accept that the horizontal fairness approach applies to out of the money creditors, in this plan there isn't a restructuring surplus, because actually that's all going to be dealt with as part of RP2. So I mean, I do rely on it for that submission very much. But that's, I mean, I think you have a position on the out of the money point, and we say the judge was absolutely right on valuation.
But I mean, I suppose the question of whether it's a snapshot, which is what I think you contend for, I mean, it has to work in tandem with 901C, doesn't it?
Yes, I think they're all the
Because
all
you
the same
can't,
concept. Yes.
I mean, you couldn't postulate a different test, I would have thought. I mean, in terms of the structure of the legislation, so you've got to be able, in an appropriate case, to say, well, we're going to disenfranchise these people. So, to make that, for the court to make that decision, there needs to be an element of certainty there. I mean, if you're going to postulate a test that says, oh, well, they may be out of the money now, but perhaps depending on certain circumstances, they won't be, it introduces, it might be said, an element of uncertainty which would make that part of the legislation unworkable.
Yes, we respectfully completely agree with that. So I mean that's what. So that's essentially we've gone back to out of the money, but I was just making the point on valuation and burden of proof. The final point, just to sweep up on valuation, is my learned friend, as part of his submissions, and this is in support of his contention that you can take Mr. Weresingh's valuation, make some adjustments to it, and sort of, hey presto, get to a position where they're in the money. And he did an exercise of trying to, if you like, identify what the target was, which he needed to hit in order to show that the Class B creditors were in the money. And on the relevant alternative basis, he said the sum needed to put the Class B creditors in the money was 20.89 billion. And he'd got there by including costs of a SAR, which he said were 288 million, and this is day one, pages 124 to 126. Now, we just do not understand where the 288 million figure has come from. If you go to Mr. Heiss's report, so let's take their own expert for these purposes in order to minimise the room for argument. Tab 16 of Supplemental Volume 2. Within Mr. Heiss's report, at page 668, he produces his analysis of essentially the cash flows within a SAR. If you go to the table on page 668, in the middle row, this is what he's called his high case. In the middle row, there is a row labelled funding requirement post HMG interest. And if you go across to the third column of figures, which is those for a SAR, assuming an exit in September 2025, and the HMG funding requirement is 1.135 billion. And then if you go over, he also does the same for his central and low case. And if you go to the second table on 669, the same figure is 1.702 billion. And as we understand, the reason for the difference in the figures is that the low, central and high case are based on different views as to the company's Totex requirements.
Where's the 1.702?
So this is, are you on page 669 of the bundle?
Yes.
There's the second table,
The low case.
which is low case, and then the same row, funding requirement post HMG interest. If you go across,
Yes.
yeah. And as I said, the reason for the difference in the figures is based on differences in assumptions as to the company's Totex requirements. And if the Totex requirement is higher, then you need more funding from HMG to cover that. But as I say, I mean, we simply don't understand where the 288 million figure came from. And I'm going to come back to this, but one of the issues we've faced in these proceedings is the insertion of what are frankly slightly random calculations, not based on expert evidence. And this seems to be another example of that. And we're going to come back to that when we come to Mr. Maynard. So, my lord, that deals with valuation. The next topic was going to be the question of releases. This was in fact the Class B AHG's second ground of appeal. Mr. Phillips didn't actually say anything about it in oral submissions. I think Mr. Day was left possibly to deal with it, but he said, I think, very little, if anything, about it. I'm going to deal with the point anyway. It's not going to take very long, I don't think. So just to set the context, that the plan contains a release provision. If you go to Core Volume 1 at Divider 2, page 55, there is a release provision, and the relevant part for our purposes is clause 16.1.2 at the bottom of the page. And it's in the sort of language you often see in settlement agreements and similar. So the first part of the clause, which you see at the bottom of that page, is very broad. It effectively is designed to capture any sort of claim you might imagine. But the key wording which limits the scope is if you go over the page to page 56, the final 4 lines, its subject matter scope applies in relation to or arising directly or indirectly out of or in connection with the negotiation, preparation, sanction or implementation of the plan and or the interim platform transaction. So it's basically dealing with claims arising out of the preparation, negotiation, implementation of the plan and the implementation platform transaction itself. What it doesn't do is release existing breaches of duty if there had been any not related to the plan or the interim platform transaction, and it doesn't release breaches of duty or claims going forwards.
It does release claims by the plan company and utilities against its own advisors, directors, etc.
Yeah, undoubtedly, yes, absolutely it does.
That does seem to me to be more, such a thing, more novel than I've seen in previous cases.
The plan company releases.
Yes, I mean, creditors releasing claims is commonplace.
And the judge relies on Matallan.
Yes.
So Matallan, Mr. Justice Miles, dealing with the release given by the creditors.
Yes.
this, and my lord says this is a release given not just by the creditors who are within the Class A creditors are within the plan party definition, or within the undertaking party's definition. Or both.
Yes.
But this includes the plan company itself releasing its directors.
Well, in my submission, there's nothing wrong with that. I mean, the plan company is itself a party to the plan and the interim platform transaction. The plan company is the principal protagonist behind this transaction.
Well, if you follow the chain of authorities back, this is one of those areas where lots of cases have been given, or judgments given by judges in unopposed cases.
Yes.
Where the language can get stretched case after case. But if you trace this back to what Mr. Justice Snowden said in Far East Capital, which is what was relied on in elected paper, which is what relied on Mr. Justice Niles, which is what's relied on here, you start with the proposition that these are all perfectly okay because it's all part of it's necessary for the scheme to be successful that claims against the directors by creditors are released. Otherwise, there'd be ricochet claims against the company.
Yes.
That doesn't apply.
Exactly, but the plan company doesn't need the plan to release the claims against the directors. I mean, that's not. Well, you could take it out, and the plan company could execute a deed of release completely independently of the plan.
Well, why? Then it shouldn't be in the plan, should it?
Well, I mean, as I understood it, the attack on this wasn't based on the fact that the plan company was giving this.
Well, I think I saw that somewhere.
Yes, it is. The judge does actually say at some point, doesn't he, that he would hear submissions on this at the consequentials hearing.
Yes, and he decided it was right to include the release in those terms. And the principal point which was being taken was that this plan is an interim plan, and therefore what you shouldn't do is include releases in the plan because it's an interim plan. And that was
Leaving all to RP2.
Yes, that was essentially the point that's been taken. And that's the point which I think we've met in our written submissions.
Which has particular resonance when it's a release by the company of claims against its own advisors, directors, because they're the ones with the obligations to take into account the interests of the creditor and all its stakeholders in devising this plan. If they get that wrong, why should that claim be released? I mean, there may well be all sorts of arguments in their favour when it comes to any claim that, well, this was all approved by the court, it was the whole plan process, and that may well provide offences, but so be it. But why should there be a release approved by the court at this stage of such claims?
Well, because the plan company is putting forward this plan in the interests of its creditors, and therefore it's right that if the plan is sanctioned and approved, then the claims that might arise in relation to this should be released. And yes, I mean, I'm just looking at the grounds of appeal on this. 269 of the core bundle, core 1, tab 6.
Hey, sorry.
269 of the core bundle, divider 6. I mean, the point which was being put against us, and I understood this to be effectively a continuation of the point that was put to the judge, was that the releases are unnecessary because it's an interim restructuring plan, and that makes it a blot and unfair. I mean, that's the ground of appeal. And that's what we've addressed in our.
So the answer to this problem is they can't do this because it's not within the grounds of appeal.
Yes, well, it's not within the grounds.
And the point wasn't taken before the judge that there couldn't be a release of the directors.
Yeah,
was it taken as, on the basis that this was an interim plan, and all releases should be left or should be deferred to RP2?
Yes, that was the basis
of the point.
Yes, the point that was being put was that this plan is an interim plan, and therefore the release, as the ground of appeal says, the releases ought to be left until the final plan.
My lords, perhaps your lordships would like to look at paragraph 58 of our skeleton.
Right.
What does that say?
The point that we make is that the judge stated that the court there was a serious risk. The directors and other officers found may face ricochet claims, and we say he didn't explain how a ricochet claim arose. Ricochet claims couldn't arise for the reasons that Lord Justice Zacaroli has identified, and we made it absolutely clear in front of the judge at the consequential hearing, and I know this because it was my submissions, we made it absolutely clear that our objection was precisely the point made by Lord Justice Zacaroli, that in the context of this plan it is inappropriate for the company to release the directors. One does not know what might happen in the future. This could all fall over. There may be claims that need to be addressed. One does not know. But what in our submission is inappropriate, without the risk of ricochet claims, what is inappropriate is to release the directors in this plan.
But does that fit within the actual ground of appeal?
Yes, my lord. Yes, my lord. Erred in law and in fact, and should have found and did not found, the releases granted under the plan were unnecessary for the purpose of the plan. In circumstances where it's an interim restructuring plan and therefore a blot or unfair. And the point is that there might, if this company goes into special administration, just suppose the sanction continues in place, the company goes into special administration because it falls over. The special administrator, this is the point I was making to the judge, the special administrator might wish to sue the directors, and it's really as simple as that.
Well, in my submission, it's not within the grounds of appeal of paragraph 8 quite clearly. I mean, the point that's been made was that it's unnecessary for the plan in circumstances where it is an interim restructuring plan. So the point being made is about the interim nature of the plan.
So it's a question of timing.
Yeah, that was the point. And it
Well, just looking at the judge's ruling on the consequentials.
yes.
Mr. Day made a different point, paragraph 6. The point taken on behalf of Mr. Phillips's clients was the one at paragraph 7, isn't it? Or I got that wrong. It was Mr. Demestre appearing there.
Yeah, so it's Mr. Demestre in my stead
Oh, right.
for the plan company.
Yeah. Temporal and subject matter limits. Yeah.
So in our submission, it's well outside the actual ground of appeal that's relied on in this case, which I've showed your lordships. I mean, that might be a moment. Could I suggest that might be a moment for us to take a break?
My lords, just before we do, just so it's clear on scopes of ground of appeal, in the core bundle, tab 10, page 299, this is subparagraph 6 of my ground 2. We say, relatedly, the judge also erred in failing to refuse to sanction the plan with or remove or qualify the releases in clause 16 there too. And our objection is precisely the objection that has been identified, which is the effect of the releases is to effectively destroy a potential asset in a future special administration. It's the objection to the company releasing claims rather than any creditor or ricochet claims. I'll come back to it in reply if necessary, but just as we were on scope of grounds, I wanted to make that clear.
Yes. Well, can I suggest we take the break at this moment, and I'll come back and say anything more about
That's
it.
a really good idea. Right, 5 minutes then, please.
Court right.
Yes.
Oh, I see. Right, yeah.
Crisis management.
Just left my glasses over at Bird last Thursday, doing a talk. That's rescue.
Yeah. I'm going to go at least to one, so probably go after one. Well, we agreed to 345. So.
No, I know that.
Yeah.
You said you were hoping you
Yeah, but that as well. So.
You said it was going to be back now. I'm just trying to keep an eye on
No, we're going. When you work on the basis, we'll go to 345.
I thought somebody did. So you're going to talk us out.
No, not talking. Not my character. They have to do quickly. They've got lots of questions. Deal with them.
Court rise.
Thank you. My Lord, so just going back to this point, as I now understand it, the objection is that the releases are being given by the plan company as opposed to the creditors. In our submission, that is outside the grounds of appeal, and it's not open on that basis. Without prejudice to that, we submit there's no reason why a release given by the plan company can't be properly included in a plan or scheme. Firstly, as a matter of propriety, if the court has concluded it's going to sanction the scheme or plan, then there's no reason not to include such a release within it. The release is only included on the basis the court considers it's right.
Well, I mean, that's the point, that the release is limited to
Yes,
the implementation of the plan and so forth.
yes.
So it's not a general release, that's
Exactly, quite. Secondly, there would be a risk of derivative claims, particularly in the circumstance of this case. And I'm just thinking of the possibility of a derivative claim by the shareholder, for example, who we are not in good relations with, and who's effectively been opposing the sanction of the plan. And what one obviously doesn't want is the prospect of the shareholder coming along and effectively saying the company has failed to prosecute a cause of action against its directors, and therefore on that basis they're entitled to pursue a derivative claim. So there is the risk of a ricochet claim for that reason. But thirdly, as a matter of general discretion, The reason for including this release, particularly in a case like this, which has been contentious, is to avoid what would otherwise be the absolute distraction of the directors and their advisors being threatened with claims by dissentient creditors and shareholders going forwards, which is going to not be something the directors and their advisors should properly be subject to, but be hugely distracting and counterproductive in practice when the group needs to get on and do RP2. So we don't see what is offensive about this. I'd also add it's not been said or even identified that there has been a breach of duty. So I mean, if the concern is that, oh well, the company's giving up some valuable asset here because there is in fact a claim for breach of duty, or even that there might be, that's not something that's been alleged. It's not something that's been supported by any evidence. It's not something that was even put to either of the directors who appeared to give evidence. And so there's no basis on which your lordships can conclude there's some valuable asset that is somehow being released as a result of this.
I was going to ask you what the potential claims there could be in the circumstances based on effectively the putting forward the plan.
Yes.
I mean, if it involved something that was not just unfair but wrong, arguably would block them.
It would. Why would the court sanction it? So the reason for including the release fundamentally isn't because the company, or indeed any company, thinks there is a valuable claim here and a viable claim for breach that needs to be released. And indeed, in circumstances where the court has sanctioned the plan on the basis of days of argument from dissenting creditors, it's difficult to see how such a claim could get off the ground. The reason for releasing this is where you have dissenting creditors and shareholders. They will do whatever they can to undermine the plan, undermine the company going forwards in order to get leverage. And the reason for this is to effectively stop that. It's not something that the directors and their advisors should be subject to in circumstances where the court has decided it's the right thing to do is sanction the plan.
That's the whole point, isn't it? Because the releases carve out gross negligence, willful misconduct, or fraud.
Yes.
So they're not dealing with that at all.
Yeah.
So that's still, as it were, at large. What this is dealing with is an allegation that the directors are in breach of duty because they failed to take account of something they should have taken account in entering into the plan and or supporting the plan in circumstances where, on this hypothesis, the court has sanctioned the plan. So in effect, I think this is your point. The B creditors, were they to take this point, or somebody in the position Mr. Maynard takes, would effectively seeking to go behind the judge's judgment.
Yes. That's exactly right. I mean, the practical reality is without this sort of clause, the court sanctions the plan, and the next thing that happens is there's a 10-page letter from Quinn Emanuel that comes in saying, what are the directors of the company doing to investigate claims against the directors and their advisors?
Are you saying that's happened a lot in the past, despite these sort of releases not being there in the past?
Well, I mean, we don't accept that they're not typically included in schemes or plans. I've just spoken to the team at Linklaters, and they'll give me the list they came up with off the top of their head. But if it's helpful to have a list where,
I don't see how it is.
I mean, the EDF, I think Teleclumbus was just two that were just mentioned to me. So, I mean, we don't accept that they're not typically included in schemes or plans. But those are my submissions on this. I mean, the point that now seems to have fallen away, which was the one I was going to address, is that was about the nature of the plan being an interim plan, means that the releases shouldn't be granted. And we say that's actually a reason in favour of granting the releases, for the reasons the judge gave in the judgment at 2826, not least because there is going to be a second plan here, and one of the benefits of the release is to avoid the distractions. So I think I'm going to turn to the other discretionary matters that are relied on. So we're now into a sort of topic of dealing with all the other discretionary issues. The fourth ground relied on by TWL is that the judge should have held that the fact that better terms might have been available for the super senior financing was a reason for not sanctioning the plan. Now, the main point we'd make about this is the judge considered the terms of the super senior financing in great detail in his judgment. He took this well into account, as you can see from reading his judgment. It's not said he made any error of principle, and he weighed the points and attached such weight to them as he thought fit. But overall, he decided he should exercise his discretion to sanction the plan. And ultimately, what this ground amounts to is nothing more than saying that he should have exercised his discretion differently. Actually, he should have come to a different view in weighing the costs of the super senior financing. And it's essentially an appeal against the exercise of the judge's discretion. So that's our first point. But in any case, we say the points made by TWL are in any case wrong. Firstly, on the costs of the super senior financing, it's said in the argument that those costs are excessive and that they represent, quote, ransom terms, unquote. TWL adduced no evidence to that effect before the judge. They didn't put that suggestion to any of the company's witnesses, both fact witnesses and experts. And having failed to do that, the point's not open to it. Now, in terms of the evidence that
gets quite close to an allegation of dishonesty.
the ransom terms point,
Well, it might be said to be an allegation of
Yes.
dishonesty because it's effectively saying, well, you've hiked up these costs and then tried to bludgeon us into agreeing to them, as it were.
yes. I'm not sure what ransom terms, I mean, it's difficult to sort of understand what it really means once you drill into it, but it just was, there was no evidence put forward by TWL to support that whatsoever. And in terms of the evidence which the judge did have, he had evidence from the company and also from the Class A AHG that the terms of the super senior financing were part of the overall package of pricing of the interim platform transaction as a whole. Now, if I can just take you to Mr. Burleson's witness statement, which is in supplemental volume 2 at 12, tab 12. And if we pick it up at page 483, paragraph 29, so he begins at paragraph 29 by saying the interim platform transaction has 4 cornerstones that developed in light of the deteriorating financial position of Thames Water and which were negotiated against a rapidly receding liquidity runway. Each cornerstone is critical to providing Thames Water with a stable platform, and then he identifies what he describes as the 4 cornerstones. And the first is the provision of up to £3 billion of new super senior financing. The second is the covenant relief, so in essence relaxing the contractual restrictions on Thames. Thirdly, the 2-year maturity extensions and amortisation relief, and fourthly, the release of the trapped cash, and that's the approximately 400 million that was held in blocked accounts and required majority creditor consent in order to be released back to the company. And then when you go to 361, so 36.1. He then describes it, it's the pricing of that transaction, i.e. the interim platform transaction, that had the different elements to it, and he identifies those elements there. Then coupon, the original issue discount, the call protection, the backstop fees, and the consent fees. Now, the first point I'd make is those pricing elements, as he describes it, are the pricing elements for the interim platform transaction as a whole. So the 4 cornerstones he identified, it's holistic. So the way this was looked at by the company and the Class AHG interim platform transaction with those different limbs to it, and the pricing for that transaction includes these different elements. Now, what you can't do, in my submission, which is what the appellants have done, is to take those 5 elements Mr. Burleson sets out in paragraph 36 and say that those are solely attributable to the super senior financing. They're not. That's part of the interim platform transaction. But another obvious part is they were, in effect, releasing 400 million of cash back to the company and agreeing to maturity extension on £2.9 billion of debt. So ultimately, it's not, the way this has been effectively approached for forensic purposes is to take all the costs and say, and lump everything on the super senior debt and say they're all costs of super senior debt, and that, my submission is not right. The interest rate, just to deal with that, is 9.75% on the super senior debt. As I said at the start of my submissions yesterday, that is not out of line with the estimated funding cost from HMG in a SAR, which Mr. Cowlishaw put at 9.5%. That's, we don't need to turn it up, I'll read the reference. It's supplemental volume 1, tab 5, page 104. Yeah. And Mr. Heiss put it at 8.87%. And that's supplemental volume 2, tab 16, page 675. So, I mean, if you're, I don't understand the submission as to how it can be said the 9.75% is a random ransom term, given where the experts were coming out as to the likely coupon in a SAR. There's also, in our submission, a level of risk attaching to the super senior financing. It's right to say it has a high level of priority within the capital structure because it's super senior. But as Mr. Burleson says in paragraph 36, there's at least 3 areas of risk. The first is that if the company was to go into SAR, then this debt would rank behind what HMG puts in at that point. And the language is, which the profession tend to use, is that it would be primed by HMG, because HMG would put their funding in on top, so this debt would then get pushed down. Secondly, the expected time it would take for repayment in the event of a SAR. So if the company goes into SAR, it's not expected. This debt would then be repaid immediately. There'd then be a question about how long that takes. And then thirdly, as Mr. Burson said at paragraph 36.3, the time for repayment of funding in the plan scenario, which is itself dependent on the equity process, potentially also on the CMA appeal. Now, just whilst we're on this, in the judgment at 113, which is core 1, divider 3, page 128, the judge made an error, which has regrettably been alighted on by my learned friends. Paragraph 113. He says there, as Mr. Day pointed out, the super senior funding is very low risk, as Mr. Cowlishaw accepted in cross-examination. He didn't accept that. That's an error. Now,
What about the other point in that paragraph? I mean, the point made against you generically is these are findings made by the judge, which you're now trying to challenge. So, for example, in 119,
yes,
he records Mr. Cochrane's acceptance that the cost, purely the cost of continuing financing new money, was £800 million. And in paragraph 113, no justification was given for the discount. So those are the targets you have to meet.
yes. I mean, I am going to deal with that. I mean, there was a section in the evidence dealing with the base of the original issue discount. I mean, the 800. Well, we'll come to the 800 million. The 800 million figure includes the actual liabilities which the company would discharge. So and I'm not sure this is an error which the judge made, because he's making the point there that the 800 million would be used to meet the continuing interest payments. Where we do take issue with is the description of the 800 million as a cost of the super senior financing, because what the 800 million reflects is the fact it's not a cost of the super senior financing, but the fact that is used and will be used to meet in part liabilities on the existing debt.
What would be helpful is to have your analysis of what's made up in that 800
Yes.
million.
I think I'm going to do that.
Yeah.
I hope I am anyway. If not, I'll be corrected. I'm going to go through these figures. And in fact, the first set of figures I want to go through is what TWL asserts is the costs of the super senior financing. So if you go to TWL's skeleton at the second core volume, divided 15, page 373. Yes.
373.
Yes, at page 67, 373. So this was the target. I said to myself, because their assertion is that the cost of the super senior financing over 6 months would be 443 million.
Sorry, I've lost where you
So
were.
it's so core volume 2, divided 15, page 373.
Oh, the skeleton below. This is the judge.
Yeah. Yeah. So this is the yes. This is the no. This is not the skeleton below. This is TWL skeleton on appeal.
So which
Yeah.
paragraph?
So paragraph 67. Yes. The TWL skeleton on appeal, page 373 of the bundle. So what they submit is that the cost of the super senior financing over 6 months would be 443 million before early bird and consent fees are taken into account. Now, that 443 million came from Mr. Maynard's closing submission. So if you just leave that open and take out supplemental volume 3 at divider 35 and go to page 1114.
Sorry, supplementary bundle.
Supplemental bundle 3, divider 35, page 1114.
Yeah.
So this as we understand it, is where the 443 million comes from, and you can see how it's been broken down there. Now, just to get one point out of the way, if you go back to 67 of
In the judgment.
so 67 of TWL skeleton, so
The
back,
TWL
just what we were just looking at a moment ago, page 373 of core bundle 2. It's obviously wrong to say that the 443 million is before early bird and consent fees are taken into account, because the 443 million, as you can see, includes the early bird and consent fees. So that is wrong. And then, so that's the first point we make. The second point is, in our submission, the 443 million wrongly treats the early bird and consent fees as costs of the super senior financing, rather than being paid in return for agreement of plan creditors to the plan and the interim platform transaction. And just 2 points on that. The entitlement to the early bird and consent fees is not linked to a plan creditor participating in the super senior financing. It's paid in return for their agreement to the interim platform transaction and the plan as a whole. And indeed, the early bird and consent fees are open to plan creditors who would not have been able to participate in the super senior financing, so namely the hedge counterparties.
Yeah.
And that's the second point. So we don't accept it's right to treat the early bird and consent fees as costs of the super senior financing. Thirdly,
They're conditional presumably on the plan being approved.
yes,
Yeah.
yes, that's right. Thirdly, the calculation ignores the other benefits obtained by the plan company. So if you're looking at these costs, actually you also need to take into account the other elements of the interim platform transaction, which is principally the release of the 400 million in trapped cash and the extension of the debt maturity on 2.9 billion of debt with no increase in interest rates. So if you just take the maturity extension on 2.9 billion pounds of debt, creditors would have been entitled to ask for a fee in return for that, or possibly an exchange, an increase in coupon of some kind. That would be entirely normal. The way this transaction has been structured is there isn't a discrete fee for the increase in maturity, but it's reflected in the terms of the pricing of the overall transaction. Fourthly, we do suggest also that the suggestion that these are costs of borrowing 1.388 billion for 6 months is somewhat misleading, and that's because the OID, the backstop fees and the make-whole fee are payable in return for the potential to borrow the full £3 billion over the full potential term of the facility, which is 2.5 years from first utilisation. So when you're looking at the costs of the super senior facility itself, it's not right in our submission to treat these as costs of 1.388 billion over 6 months. Actually, what the facility makes available is the ability to have 3 billion over 2.5 years, if that's what the company needs.
There's no presumably clawback or whatever if you don't borrow the full 3 billion.
I don't think so.
No.
No.
So it's the possibility of 3 billion with the certainty of 1.388.
Well, it's more certainty of, I mean, I quibble with the 1.388 as well, because, I mean, actually the first tranche of the facility is 1.5 billion, not 1.388. That 1.388 figure has just been taken on the basis of a drawdown schedule to the end of July.
Yeah.
To the end of July 2025. So I mean, it's a completely arbitrary figure itself in a sense. I mean, we don't agree that it's going to be limited to 1.388 billion from the company's perspective. And we know now that there is a CMA appeal, for example, which was the principal condition precedent to drawing down the second tranche of the 1.5 billion. Next point is not reflected in TWL's analysis, but none of the early bird and consent fees are payable in cash. They're payable in debt. So they're not a cash outlay by the group. In relation to the early bird and consent fees, the group is not going to pay out cash. It's going to issue debt instruments in the amount of those fees. And those can expect to be restructured as part of RP2. They will form part of the group's debt stack and it's that debt stack which will be restructured as RP2. So the sort of implied suggestion that these are cash payments is wrong. And similarly, the make-whole fee, although it's payable in cash, it's likely to form part of the debt obligations to be restructured in RP2.
When's it payable? When would it be payable?
Well, it would only be payable if the facility came to an early end. Yeah, so it would become payable if the facility has been terminated before the full 2.5-year term. So it falls due at that moment of termination. So if there was a refinancing or repayment of that nature. So obviously the purpose of the make-whole fee is to compensate the lenders for the return they would otherwise have got over the full 2.5 years of the facility. So it falls due if the facility is terminated at some point earlier than the full 2.5 years, and it covers the period from that date of early termination to the
actual termination date. What would have been the termination date?
Exactly. So what is likely to happen in this case in relation to the make-whole fee is it won't fall due. We'll do RP2. As part of RP2, this debt will be restructured, and therefore the make-whole fee will form part of the debt obligations to be restructured in RP2 and will be taken into account at that point.
Is it a fixed fee? So even if you repay early 3 days before the maturity date, you pay 156?
No, it's not. No, it's, as I say, it's to compensate for
so
the...
how's the figure of 156 been arrived at?
I think they've just taken that on the basis of the estimated date of RP2, haven't they? Yeah. So they've just, I mean, it's another...
That's not correct. It was set out in a letter from Aiken Gunn. If you go back to my appraising submissions and the table that one sees at 1114, one sees I provide a document reference to a letter from Aiken Gunn setting out the projected costs of this funding for 6 months. And the reason why we had to go with 6 months was these were the only figures that I had to cross-examine Mr. Cochrane on at trial. The company hasn't been forthcoming about how the costs
we don't
rack
accept
up.
that. I mean, I'm sorry, my own friend's standing up to make contentious submissions. We don't accept that at all. In fact, my point is right, as my friend's just demonstrated. The 156 million is based on the assumption that there would be, in effect, a termination of the super senior financing facility in 6 months' time. So it's based then on the estimated period from then until the facility would have expired 2.5 years later.
And is it assumed on your side that in an RP2 there would be a termination of it, thus giving rise to the fee?
Exactly. So we have assumed as part of our analysis that fee will come in, but it won't be paid in cash. It will be restructured alongside the other debt as part of RP2. And I think both experts, that's the approach both experts, Mr. Heiss and Mr. Cowlishaw, took in their analysis.
Yeah.
So the reality is the make-whole fee is also going to be, in effect, a debt obligation which will be restructured as part of RP2. So the suggestion that there's £443 million of costs with the implication that they're paid in cash by the company, and this is all costs of getting 1.388 billion for 6 months in our submission, is just wrong. It doesn't reflect the reality. Now, the second figure is the 800 million figure. So this is a different figure of costs said to be attributable.
Before you move on, one element of that was the £45 million original discount fee, which the judge said no rationale or justification had been given for.
So,
and that's true also of the backstop fee, isn't it? So,
yeah, so the easiest way to pick this up is if your lordship goes to our respondent's notice at core bundle 2, page 12, page 312. So far as it's paragraph 3 so far as the backstop fee is concerned, and then paragraph 2 so far as the OID is concerned. in our submission, they were dealt with as part of the evidence, principally the evidence of Mr. Burleson, but also the evidence of Mr. Fraser, the Group's General Counsel, and it was also dealt with by Mr. Thomas Watson in cross-examination when Mr. Alatar put questions to him. So we don't accept the judge's right to say there was no evidence on this, for the reasons in paragraphs 2 and 3 about respondents' notice. And I mean, the backstop fee is hardly unusual. I mean, it's entirely right to say backstop fees are commonplace, and the reason they're commonplace is they're provided for a commercial underwriting service. The person who is entitled to the backstop fee is providing something of value in return. They are agreeing to underwrite the provision of the new debt, and that's the reason those fees are paid in this case. And then the other figure that has been sort of bandied around is the 800 million of costs figure. And again, if you go back to Mr. Maynard's closing note, which is in supplemental bundle 3 at page 1117. This, I think, so it's not 1117.
Looks like it.
Yes, it is.
Yeah.
Yes, it is. You're absolutely right.
Yeah.
So what he's done in essentially paragraph 25 is go through a number of the different elements that he says lead you to that conclusion. So if we just sort of take the sub-paragraphs in turn, the 443 million I've already dealt with. In our submission, that's not right to describe that as costs of the super senior financing. The 245 million, fair enough, that is used to pay interest on the extended maturity of the Class A and Class B debt over those 6 months. So that is obviously one of the purposes of this plan, is to enable the company.
It's an existing obligation that would have had to be discharged, otherwise there would have been an event of default.
Exactly. So it's effectively paying the existing interest obligations to get us to RP2.
Can I just ask you the same question I asked the others, which is what would be the position in the SAR in relation to the payment of ongoing interest on the outstanding debt?
So both experts were agreed on this, and I'll give you the references a moment. Both experts agree that cash interest wouldn't be paid in a SAR. Both the existing interest and any default interest would be capitalised, and it would therefore fall to be paid effectively on the exit from a SAR as part of the distribution of the exit proceeds. And if you want the references, I'll just read them in. It's Mr. Cowlishaw's first report at page 83, which is supplemental volume 1, divider 5, page 133.
Mm-hmm.
And Mr. Heiss at his first report, Heiss 1, page 54, sub 16, 669, and page 61, sub tab 16, page 676.
Yeah.
So they essentially agreed on that. And I mean, just to make another point off the back of that, that of course is the reason why, on our case, the Class Bs actually do better under the plan than in a SAR, because in a SAR we're projecting they wouldn't get anything because the interest wouldn't be paid, and by the time it comes to distribution of the proceeds, they're going to rank behind everyone else and they're not going to get anything, whereas under our plan they will continue to get interest paid until the transaction takes place as part of RP2, and it's that drives the fact they get a better return on our valuation under the plan versus the position in SAR.
Which you say you're giving them when you don't have to.
Yes. Now, so on the 800 million cost figure, if we go back to 117, so the 245, I think is right. The 210 million of professional fees in our submission is not right. And if it bears with me, lost my, so the 210 million in professional fees that came out of Mr. Cowlishaw's evidence, sorry, Mr. Cochrane's evidence in cross-examination. What he didn't say, contrary to what's said there, is that those are costs of the plan. Effectively what he says is that those are costs of the process. And if you go to our skeleton argument, please, for the appeal, and this point we deal with in paragraph 110, subparagraph 2, page 460. So subparagraph 2, so far as costs are concerned, Mr. Maynard's counsel asked the Chief Financial Officer in cross-examination about the cost being incurred by the group, which he put at a burn rate of approximately £15 million a month. And that's right. However, these do not represent the cost of the plan alone, and Mr. Cochrane did not say that they did. And we've given you the references to the transcript. I mean, perhaps it's worth just turning those up. So it's firstly day 1, page 175, which is in transcript bundle 2, page 83.
Tab 2.
Tab 2, exactly. Yes, page 83. So we'll perhaps pick it up at page 174, line 19. As I understand, Mr. Cochrane, none of the numbers you've been discussing would include all the costs of this restructuring. The costs of restructuring are estimated including the cash flow. They are, so in the burn rate of 200 million includes those costs. It does include a monthly run rate of advisor cost. Frankie, would you like to tell me what there's? The current burn rate on an advisor cost only is about £15 million a month. And that is the run rate on all advisor costs. And if you go to day 2, page 11, and this is in the transcript bundle divider 3 at page 157. So it's not, that reference is wrong, it's page 129.
129.
Yeah, so it's really, if you go to page 15 of the internal transcript,
Yeah.
and pick it up at line 2, up to the end of this first restructuring plan, what is the amount which Thames Water is paying to cover the Class A ad hoc group advisor professional costs? I don't have that aggregate figure. Unfortunately, can you give me a ballpark? I can't, unfortunately. Well, and then within that 15 million, there's a whole variety of different advisor fees. It's not exclusively the A creditor class. It is all fees relating to that the company is incurring in relation to this restructuring plan, including legal fees and other advisors' costs. Bulk of these fees to date have been our own legal fees. And then line 20, so in aggregate, the costs that Thames is incurring for the equity process, and the process up to this, the end of this restructuring plan, can you give me an estimate for how much Thames Water spent on this process? This is an estimate, I believe it will be in the region of 100 to 120 million. So 100 to 120 million, you say, financed entirely out of cash flow. Correct. Now, the point, as we say in 110.2, is those aren't costs simply limited to this restructuring plan, RP1. They include the costs associated with the final determination, the CMA appeal, the equity process, and essentially all other advisor costs the company is incurring at the present time for everything it is undertaking. So final determination, appeal of the CMA process, equity process, preparation for RTP2, liquidity management and forecasting. So what we don't accept, and it's not right, is to say that those costs are somehow all attributable to this restructuring plan, this interim restructuring plan. That's not the position. That's not the position at all. With respect.
And what, you maybe can answer this, what proportion of that total, of those total costs is, as it were, a liability this company will incur as a result of the plan being approved?
Well, that's also a very good point, if I may say so, because if you go back to 1117 of Mr. Day's submission, and he comes up with a figure of 210 million. And as I understand it, what he's done is he's taken the 100 to 120 million figure, which Mr. Cochrane gave of costs incurred today, and then he's applied a £15 million a month run rate up to September 2025, and he sort of added those together and said that gives you 210 million. But of course that is completely wrong, because the existing 100 to 120 million has already been paid out of cash flow.
That's true
Yes.
of the non-company advisors as well, is it?
Yes.
Right.
So that's what's been incurred to date and gone.
Yes, that's been paid
So
out
it's
of
not,
cash flow.
it's
And in
not
fact,
on any view of cost of the restructuring.
exactly, and
And the 90 million is 6 months at 15 million.
exactly right. Yes, and this, in fact, I thought it was here, but if you go to page 16, lines 2 to 4, so Mr. Day, in fact, puts this to Mr. Cochrane. So 100 to 120 million, you say financed entirely out of cash flow. That's correct. So the existing 100 to 120 million has been paid out of cash flow. And then you've effectively got the continuing 15 million month, which would go up to the end of 30 September 2025. So even those costs are costs of the whole process, not this plan. I mean, this plan will be sanctioned, we hope, and upheld, we hope, by this court. Those costs going forward are going to be the equity process, RP2, liquidity management, dealing with the appeal of the final determination to the CMA. So with respect, that we say is a completely misleading figure. And then, I mean, on the hedging payments and management retention costs, I mean, Mr. Cochrane, I don't think accepted that there were any further liabilities to come in relation to that. And then the nub of this is that by the time you get to subparagraph 5, I mean, the idea that you say that there's about 500 million available, which also assumes the wrong starting point of 1.388 billion. It just doesn't stack up. I mean, it's not a sound calculation. And I mean, this does go back to a complaint I'm going to make, which is Mr. Maynard came into these proceedings very late. He didn't put in any expert evidence of any form dealing with these sort of issues and these sort of calculations. What happened was Mr. Day asked the witnesses some questions in cross-examination, and then in Mr. Day's closing submission, which I think we got something like a couple of hours before all the closing submission were to start before the judge, we got these calculations put forward for the first time. They should have been in my submission properly the subject of expert evidence. This sort of material is going to be put forward. It ought to be put forward in that sort of form. And it's very unsatisfactory for these to effectively sort of sprung into the proceedings, where the reality was we didn't actually have an opportunity to challenge these properly in front of the judge because of the way in which they were put in. So ultimately, we say those figures are just completely unreliable. Now, the other point about the cost of the super senior financing, which formed a key part of the judge's judgment, and on which we say he was entirely right, was that he found that the super senior financing will form part of the debt to be restructured in RP2. And that includes not just the principal of the super senior financing, it would include the make-whole fee, it would include the early bird and consent fees, to the extent you're regarding those as costs of the super senior financing at all. And his point was, well, that's just going to be form part of the debt stack, which will be restructured in RP2, and essentially, therefore, the cost of this will be borne by the creditors. And in my submission, he was exactly right about that. TWL says that's something that's not supported by any coherent evidence. In our submission, that's wrong. It's always been clear that the present plan is an interim solution intended to act as a bridge to RP2. RP2 will be a recapitalisation transaction in light of the equity bid process, which will establish the enterprise value of the group.
Yeah.
Now, based on the judge's findings on valuation, the enterprise value of the group, as at the date of RP2, is going to be much less than its debt stack. And if you go to paragraph 16 of our skeleton argument, back in core bundle 2, just give your lordships the figures. It's paragraph 16 on page 410. So in the third sentence, the relevant figures are Mr. Singh put the enterprise value of the group at 30th of September 2025 as 16.71 billion. But the projected debt burden at that date is 24.84 billion. And if you go, and perhaps it's worth just turning that up a bit, just so you can see how the debt burden's been put together. If you go to supplemental bundle 2, divider 22, at page 810, yeah, so there's a table, and the relevant column for these purposes is the third column of figures, scenario 1, plan and RP. And you can see that comes to 24.84 billion, but included within that, you have the super senior funding of 1.92 billion. And then the Class A debt is split into two parts, the part that carries with it a right to a make-whole and the part that doesn't. Those are 9.08 billion and 7.6 billion. In total, that's 18.63 billion. And then the Class B debt, the subordinated debt, and the intercompany loan. So the total debt burden is 24.84 billion. So on Mr. Wera Singh's valuation, the company is going to be about 8 billion in the red, effectively. It's going to have negative equity value of £8 billion. Now, we say it's really a matter of common sense that any equity transaction that's going to take place as part of RP2 is going to require a restructuring of the debt, because no rational equity investor is going to put money into a company in return for a negative equity value. So in order to enable the recapitalisation transaction to take place, the group's debt burden will need to be restructured or reduced in order to reflect its enterprise value. And the judge was entirely right to conclude that the likely outcome of RP2 is that the Class A creditors will have to take a significant haircut, and the price of the new debt would have to be borne by the planned creditors themselves, and specifically the Class A creditors. So he was absolutely right about that. Now, I mean, it's interesting to note in this context, we might suggest that Ofwat's own position is that it agrees with the judge's conclusion at 253 of the judgment that it's likely that the price of the new debt will be borne by the planned creditors themselves. If you go to supplemental volume 3 at divider 39, page 1232. And this is really the point they make at paragraphs 8 through to 10 on page 1232. And the basic point here is, under Ofwat's approach, a water company is allowed effectively a standard return for its debt and equity. If a water company in fact incurs costs in excess of that, it can't recover those by increasing the bills to customers. In effect, they have to be borne by shareholders, or in this case, creditors.
Well, they say in first sentence, paragraph 9.
Yes.
Ofwat also ensures that cost-sharing arrangements which apply to over or under expenditure do not apply to costs relating to financing.
Exactly right.
And that includes refinancing and takeover costs.
Exactly right. Exactly, and then
also, advisory costs to the extent they relate to refinancing.
yes.
So
Exactly, and then the sort of nub of it is paragraph 10, where they explicitly agree with the judge at paragraph 253 of the judgment. It's likely that the price of the new debt will have to be borne by the planned creditors themselves. And there's been sort of criticism of Ofwat for not coming along to court and intervening and making submissions. Ofwat's view is this is a private sector matter between the company and its private sector creditors, and in that it doesn't affect customers, and therefore Ofwat doesn't need to come along. And it's explained why it thinks it doesn't affect customers, and it I think it's fair to say, regards this as a matter between the company and its private sector creditors, for them to sort out between themselves. But on this specific point, they are quite explicit that they regard these costs which will be borne by the creditors, and specifically the Class A creditors, and mainly Mr. Alatar's clients, quite frankly. Now, the other point to emphasise on the outcome of RP2 is there were two sets of expert evidence from Mr. Cowlishaw and Mr. Heiss, which modelled the estimated returns in RP2. And both of those took the same approach. They both assumed that there would be a transaction that took place on the basis of the enterprise value of the group at that stage. And that enterprise value would be applied down the waterfall to creditors. So they took different valuations as a starting point, but the methodology was the same. And it was assumed by both of them that what would happen as part of RP2 is the enterprise value of the group would be established, the creditors would get the benefit of that. It would be applied to them in accordance with their existing priorities. And depending on what the value was, a creditor would or wouldn't get a return. And so there's no dispute between them as to the methodology or approach. The only real dispute was as to the starting valuation and also as to the effect of the June release condition. So in my submission, that is sufficient to dispose of this ground of appeal from TWL. We also have a specific respondent's notice point, which is in core bundle 2 at divider 12/314. It's paragraph 5. So we challenge two things the judge said, and I accept this is, we're now in the territory of effectively getting into the judge's findings. My primary position is that the judge was right, it's a matter of discretion, you don't get into this. If my learned friends are right, that actually it is open to this court to start revisiting points, then we challenge this point. And specifically the finding that TWL might have found better terms in the market from new funds who are not exposed to the planned debt. And in our submission, there wasn't an evidential basis for that conclusion.
I think Mr. Thornton frankly accepted an answer from us yesterday. There was no evidence for that.
Yes, he did. So there was, I mean, that was my point. There was no evidence of that. This is just, it was no evidential basis whatsoever. The super senior financing as well, which we did get, was part of an overall package which included various other elements. But also the introduction of that required the consent of the majority Class A creditors. And there was no evidence, not only was there no evidence of an alternative funding, but there was no evidence of an alternative funding that might have attracted the consent of the Class A creditors and therefore allowed us to implement it. So we respect this, there just wasn't, that finding is not something for which there's an evidential basis, and it sounds like I think Mr. Thornton did accept that. So I'm going to turn then to the position of Mr. Maynard MP, and we've covered some of this because I've already dealt with some of his calculations as part of dealing with TWL's ground 4.
Are you going to deal with the comparative costs of the SAR?
Yes, I am. I think that.
Paragraph 293 of the judgment, I particularly noted, because what the judge says there, I think I'm right, is that effectively that the costs of the SAR, I mean, leaving to one side whether they would have been upwards of 3.35 billion.
Yes.
The costs of the, I'm prepared to accept the costs of the SAR are likely to be equal to or more than the cost of RP1 and RP2 on the basis of the high cost of financing under the plan.
Yes.
And that's not challenged on appeals, I understand. Yes.
On the by us.
No, by any of the because what that's really saying is, well, the SAR would have been just as expensive as the plan.
Exactly. So I mean,
our paid to the suggestion it's some sort of ransom, or a sort of financial equivalent to a ransom strip, which I think is where that's coming from.
Yes. So absolutely. So, I mean, our position on this is, I mean, on the cost of the SAR. I mean, ultimately, our position on appeal is that's what the judge found, and there's no basis to go behind it. Our fallback position on the respondent's notice is actually who's been rather generous to the appellants in making that finding. And if one was to get into it, we've got a number of points as to why the cost of the SAR would in fact have been more, and why that's the judge, and that's what the judge should have found. But our primary position, and I think this is what we say in the skeleton, is that was that was a conclusion which was open to the judge. I accept, in line with the rest of my submissions, that it's not something one can go behind. But we do have a fallback as well, which is but I am going to come. I will come to that, and that is part of my my topics for Mr. Maynard. Now, just very briefly, just a couple of introductory points in relation to Mr. Maynard. Mr. Maynard obviously puts himself forward as effectively articulating the sort of public interest in the plan and to your lordships. Your lordships, in my submission, need to be careful about that, because the court does have the views of the independent regulator, Ofwat. Now, Ofwat is an independent regulator, and it's Ofwat that is given the duty by statute to protect the interests of customers, and that's sections 2A and 2B of the Water Industry Act 1991. It has a specific statutory duty to protect the interests of customers. So, if you like, the question of whether the plan does anything to harm the interests of customers is something that's right within the bailiwick of Ofwat.
Yeah.
And Ofwat has made its position clear. It doesn't object to the plan, and it has explained why. And essentially, it doesn't think the plan affects customers. It's a private sector matter. The company and the creditors should sort it out in the first instance. And my lord, that is something we submit carries more weight than Mr. Maynard's views. You've got the view of the actual independent regulator, which has the statutory duty. Secondly, although Mr. Maynard purports to represent the public interest, it's clear that there are others who might fall within that rubric who take a different view. Most obviously Ofwat, but also the pension trustees, who did put in material before the judge to make clear their position, essentially on behalf of pensioners, that they preferred the plan to SAR.
Just remind me where they fit into the debt equity structure of this group.
Well, it would be an unsecured. So if it went into SAR, it would be an unsecured.
Creditor of which company?
Well, probably all of them, because I think TWUL is the employer. So there would be a Section 75 debt, I think, against TWUL, because TWUL is the employer of the pension scheme, I think. But I suspect other group companies would probably be liable as well.
I assume that we're talking about a restructuring only of this financial debt.
Yes, so they're not being restructured by the plan at all. But their point was, oh well, a SAR is going to be worse for us than a restructuring of the group that keeps it out of SAR, and that's because of the consequences of SAR in relation to the pension schemes. So it's not the case that Mr. Maynard represents the sort of universe of the public interest. There's different voices, there's different views out there. He has a particular view. His industry, the groups he's sort of aligned with have a particular view, but it doesn't represent the public interest as a whole. And then the third point is, just going back to the point I made earlier, that there is an issue in our submission about the nature of Mr. Maynard's intervention, and particularly in relation to these calculations that were put in effect through questions put to witnesses, and then in the closing submissions. And there's been an attempt to put yet a further calculation in his skeleton argument on this appeal. And in our submission, the general approach of the court, quite rightly, in Part 26A proceedings, is to say that evidence which should properly be the subject of expert evidence should be put in by way of properly compliant Part 35 expert reports. And the reason for that is it puts the parties, but also the court, in a very difficult position. If you have these calculations effectively put forward by counsel, essentially representing counsel's attempt to interpret the figures and then put forward as the costs of a SAR, that isn't very helpful material. And what the court is entitled to expect is an expert who's to come along and applies his mind to it and come to a view that he or she is willing to put their name behind. And if I can just show you one authority on that, it's the,
Well, I mean, you make the point about Mr. Burleson's evidence as to what was or was not cost of financing,
Yes.
as opposed to something else.
yes,
And that the judge accepted Mr. Burleson's evidence, and he
Yes.
accepted Mr. Burleson was an honest and truthful witness.
yes, yes. So, I mean, Mr. Burleson was,
So there's no point in Mr. Day saying, well, these are actually costs of financing, if the actual evidence before the court, in the first instance, was, they're not.
exactly. Well, exactly right. So, I mean, there's that point as well, that essentially Mr. Burleson gave
So
evidence.
it's not just the figures, it's the categorisation of the items, if I can put it that way.
Absolutely right, and because I mean, the court had evidence from Mr. Burleson as to what, how these, how the transaction came about in effect, and I think the judge. I mean, Mr. Burleson was an impressive witness, and I think the judge said that in his judgment. Now, if I can just show you just the authority on this point though, because it is, I think, it's potentially important generally. If you go to tab 119 of the authorities bundle in volume 6 for your lordships, and this is a decision of Mr. Justice Miles in a case called Chancellor Finance. If you go to paragraph 78 on page 13 internally of the report, and it's really
Sorry,
paragraph 78, so internal page 13 of the report.
Okay.
And what he is complaining about here is opinion evidence which was put in by a plan company on valuation and outcomes issues that didn't comply with CPR 35, not least because there was a disclaimer of any duty to the court. And if you go on, I think it's the fifth sentence in, I can see no reason why valuation and outcomes reports of this kind should not be required to comply with Part 35. The requirements of those provisions are not to be regarded as a formality. They place experts under stringent obligations and require them to ensure that their reports are a genuine product of their independent expertise. So if someone is going to come along and effectively make assertions as to the costs of funding under the plan, costs of a SAR, that sort of financial analysis, in my estimation, the court's entitled to expect that it be done by an expert report. So the court has something that an expert is willing to put his or her name to, having assumed the duty to the court, and the court isn't dependent on counsel's homemade calculations that turn up at the 11th hour shortly before oral closing submissions. So those are the sort of introductory points to Mr. Maynard. Now, in terms of turning to his objections, his first point might be said as adventurous submission, is that he contends in circumstances where the relevant alternative is a special administration of TWL, then the court should have applied a different test to sanction that gave priority to the public interest over the interest of creditors. So this is his sort of high point submission, however you want to describe it. It's essentially the judge applied the wrong test, because where you're dealing with a plan as an alternative to SAR, you need to apply a different test which gives priority to the interests of customers over the interests of creditors, and he got it all wrong because the judge looked at it and applied the usual creditor focus test. Now, we say that's wrong. Firstly, that the fairness test, the conventional fairness test for a scheme or plan is focused on how the scheme or plan impacts on those persons who are affected by the scheme or plan, and in particular those persons whose rights are affected by the scheme or the plan. So when you look at Adler at 159 to 161, it's looking at how the plan affects those people whose rights are affected by the plan. And in our submission, that is reflected also by 901C3. If we bring up authorities bundle 1 at divider 7, 901C3 is an important provision because what that says is, so we're in divider 7 of authorities bundle 1, section 901C3, which is about in the middle of the tab. So 901C3 is a mandatory provision, and it says every creditor or member of the company whose rights are affected by the compromise or arrangement must be permitted to participate in a meeting in order to be summoned in subsection 1. And you'll notice the test it uses is rights are affected by. So what it is focused on in our submission is looking at persons, specifically creditors or members, whose rights are affected by the plan. And if they are affected, actually what you have to do is convene them to a meeting, unless 901C4 applies. Now, it's never been suggested, and would obviously be wrong, to say that the customers fall within 901C3, so that we were required to convene a meeting of them. So it must be accepted that the customer's rights are not affected by this plan.
Well, they're debtors, not creditors.
Yes. Well, that's true. But also, I mean, the plan doesn't do anything to them. I mean, they remain as debtors. They have their contracts. They remain in place. The plan doesn't affect their rights in any sense at all. They're not parties to the plan, and their rights against TWUL are not directly or indirectly affected by the plan. Now, in our submission, there's no basis for broadening this fairness test against that background to reflect, still less give priority to, the rights of persons whose rights are not affected by a plan. Now, as we understand it, Mr. Maynard's argument is to say, and this I think is the high point of his argument, but his argument is to say the greater the debt burden of the group, the smaller the proportion of payments made by customers in respect of their bills that are available to be used for operational requirements and capital investment. So he's sort of saying, well, look, if you increase the debt, there's less that a company can spend on capex, fixing pipes, replacing sewers, or whatever. So the suggestion seems to be that although their rights aren't affected by the plan, they are affected in the sense that the plan might leave the group with less resource to meet its obligations to customers.
Well, they're not creditors, but they are persons to whom obligations are owed by the company.
Yes. But those are not, obligations are not affected by the plan.
No,
yeah.
but
yeah.
If taken, I wonder if it may not, it's not this case, but if the plan did have the consequence that the company would be unable to perform its obligations to the customers as well as it should be, or as well as it had done, would you not accept that that is something which can be taken into account?
Yes, I mean, if we send that skeleton, we accept that in a case where the court knew that the consequence of the plan would be to put the company in breach of its obligations to customers, i.e. it wouldn't be able to perform them, I would have accepted that comes within blot.
That's a blot.
I would accept that's a blot on the scheme or plan, because the court isn't going to sanction a plan that is immediately going to put the company in breach of its obligations to its customers. It's not going to do that, and that comes under the test of blot, which I'm going to come to. It's a relatively
But
confined.
you say we're not in that territory,
No,
because
exactly.
this is all contingent on what might or might not happen in the future.
Exactly, and there's no evidence at all, and it absolutely is not the case that this plan is going to leave Thames in a position where it can't meet its obligations. The whole purpose of this plan is Thames needs to meet its regulatory objectives. The question is how it is funded to get it in a position to do that. And the way that is going to happen is this plan and then RP2. Now, I mean, the point I was going to make is this argument of saying, well, look, if you increase the debt burden, that affects the rights of a counterparty. I mean, if that was right, then in any case of any scheme or plan, anybody who is a counterparty to the company would be able to come along and say, I'm affected by this. And in our submission, that can't be right. The test is more narrow than that. And as I said, there's never been any suggestion that the group will not fund what is required in order to meet its regulatory obligations. The question is how it's going to be met. And just on this point, we respectfully say there's a lot of force, I think, in an observation my Lord Justice Zacaroli made yesterday, because a useful thing to do is to think what does a scheme or plan do? And essentially, in our submission, what it does is it applies in a situation where you can't get consent with all your contractual counterparties to do a variation or discharge. And it effectively replicates through the statute the consent that you would otherwise need through the contract. So it's effectively a statutory replacement of the contractual consent. And that, I think, sort of illustrates why it is essentially what the scheme does is affect those whose rights, who have the contractual rights which are affected, whose consent would otherwise be needed in order to do that. And then the third point I was going to make on this, I've already made this point in answer to my Lord Justice Zaccaroli's questions. We don't go as far as saying public interest considerations are necessarily irrelevant. And there's two cases, it seems to us, where they could well come within consideration of block. The first is the case we've already discussed of where the company would be left in a situation it couldn't meet its obligations to customers. But likewise, if the effect of the plan was to put the company in breach of its licence or its regulatory obligations, that would be a reason why the court would say there's a blot on the plan as well. So we don't say they're irrelevant, it's just they operate within a relatively confined territory. And also, they come within the framework of blot. You don't need to invent a new test for sanction. Those sort of considerations where they apply fits within the established framework. They don't require the sort of reinvention of the wheel, as it were. Now, just on, this might be just helpful just to pick up the question of block before we break for lunch. My little friend Mr. Day tried to argue that a sort of extended meaning to blot. In our submission, it has a very well-established existing meaning, which you can pick up from a number of cases, but a good one is a case called Re-Co-op Bank, which is in our authorities bundle, is in the authorities bundle at tab 60.
Tab 60.
60, which your lordships will have in volume 3.
Yeah.
And if you go within that,
Yes.
and it's the paragraph 22 and the penultimate sentence. The term blot is generally understood to refer to some technical or legal defect in the scheme. For example, it doesn't work according to its own terms and it would infringe some mandatory provision of law. And I would include within that if it put the company in immediate breach of its contractual obligations to other counterparties. But it doesn't go wider than that, and it's not some sort of discretionary test that allows the court to import public interest considerations.
Well, you might say that falls within some mandatory provision of law because they're under a statutory duty. And if it's obvious that they would be driven into breach of the statutory duty, that falls within that concept.
Yes, no, I respectfully agree. I mean, if it did, if that was the consequence of the scheme of plan and the court was aware of that, then one can well see that the court may not want to sanction the scheme or plan, and that,
No.
that we would have a basis for doing so. I'm going to come to a new topic. I don't know if that's a convenient moment.
Well, if you're going to come to a new topic, perhaps we'll break it. Yes.
My lord, may I politely inquire how my learned friends are getting on? Your lordships heard yesterday, we spoke of 3:45, that's an absolute backstop, because some of us,
Sorry, what time did we say is an absolute backstop?
3:45, and that was,
Well, we'll definitely be finished by 3:45 at the latest.
Well, my own take, if I can put it that way, is that you've done most of the heavy lifting.
Yes.
Mr. Al-Attar is going to have a walk-on but starring part that will not be all that long. Am I right about that?
My lord, I listened patiently. I have, I'd say, about an hour of core material to go through, and then the other half hour of material I can go through. I can trim a bit, so I will certainly aim to finish by about 3:30.
Okay.
But that depends when exactly I get on. So if I was on pretty shortly after Mr. Smith,
How much longer are you going to be?
I'll try and get it done in another half an hour, and then perhaps Mr. Alatar can start at 2:30 and we'll finish at 3:30.
well, another half an hour, my lord, takes us to our backstop.
Sorry?
Another half an hour if my learned friend runs from 2 to 2:30, and then my learned friend Mr. Al-Attar runs an
Well, we
hour.
both know, Mr. Phillips,
Yes.
what the position is, and we're not going to start arguing about who's taking up time now.
No, I
The court's
understand
made it
that.
perfectly clear what has to happen, which is that we have to finish by 4:45. At some point, we would like to know what the timing is on any decision, and specifically whether the result is something that should be announced. We're not going to announce it today, but it might be possible to do that sooner rather than the production of an actual lengthy judgment.
Well, we would.
So we'd quite like your assistance on that at some stage.
Yes. Well, let me consult with those behind me
Yeah.
over the lunch break. And I'll
Okay,
come back.
thank you very much. So we're 2 o'clock.
Court rise.